This is a Sex Offender Registration Act continued. Sexual predator means a sex offender who has been convicted of a sexually violent offense and who also suffers from a mental abnormality or a personality disorder that makes them likely to engage in predatory sexually violent offenses. The division shall establish and maintain a file of individuals required to register pursuant to the provisions of this article, which shall include the required information of each registrant. They also have to have a subdirectory for levels 2 and 3 sex offenders. Sex offenders are classified into 3 levels, 1, 2, and 3. If a sex offender escapes from a state or local jail or hospital, the designated official of the facility or hospital where the person was confined shall notify within 24 hours the local law enforcement agency. After the conviction, the court shall advise the sex offender of their duties under this article. At the time that sentence is imposed, a sex offender shall register with the division on a form prepared by the division. The court shall require the sex offender to read and sign the form and to complete the registration portion of such form. Notice of a determination proceeding as to the level of sex offender shall be sent out by the court to the DA and the sex offender. A determination proceeding as to level of sex offender in any classification shall be held at least 45 days after the notice has been sent out by the court. So I think what that means is that 45 days is okay, but 44 days is not okay. True or false? If a sex offender, having been given notice, including time and place of the determination proceeding, fails to appear without sufficient excuse, the court shall go through with the hearing and make the required, determinations. This is 168-E. Discharge of sex offender from correctional facility. The facility shall give the sex offender a form prepared by the division to register with the division at least 15 calendar days prior to release, and the form has to be completed and signed and sent to the division at least 10 days prior to the release or discharge. Failure they have to do it within 10 calendar days. 168-F, duty to register and to verify. For a sex offender required to register under this article on each anniversary of the sex offender's initial registration date during the period in which they are required to register under this section, shall mail the verification form to the division within 10 days of the receipt of such form. So that's if the person is required to register every anniversary. A level 3 sex offender shall personally appear at the law enforcement agency having jurisdiction within 20 days of the first anniversary of the initial registration and every year thereafter during the period of registration for the purpose of providing a current photograph. And because it's a lifetime registration, they're going to be doing that for the rest of their life. (160-F) continued. A sex offender designated as a sexual predator or having been given a level 3 designation must personally verify his or her address with the local law enforcement agency every 90 calendar days after the date of release or commencement of parole or post-release supervision or probation, or release on payment of a fine, CD, or unconditional discharge. And the photograph thing, that is told if the person's in a hospital or in a hospital, and then they have to do it 90 days after release from the hospital. And the law enforcement agency has to give not more than 16 or less than 30 days notice of when to appear for the photograph. Okay, prior convictions duty to inform and register. So if there's someone on community supervision or probation when this article was like become effective, there was 2 time rules in it. There was I think a 10 days and a 3 court days or 3 calendar days, something about 3 days. So I don't think they're going to ask that though, because this has been effective for quite some time now. 168-H, duration of registration and verification. The duration of registration and verification for a sex offender who is classified as a level 1 risk and has not yet received a risk level classification shall be annually for 20 years from the initial date of registration. For a sex offender who is designated as level 2 or 3, the registration and verification is annually for the rest of their life. Okay, so any sex offender who has been designated a level 3 risk or a sexual predator shall also personally verify his or her address every 90 calendar days with the law enforcement agency having jurisdiction where the offender resides. This is I. Registration and verification as required by this article shall consist of a written statement signed by the sex offender giving the information that is required by the division, and the division shall enter the information into appropriate electronic database or file. J. Okay, so if there's going to be a change of address by someone on probation, they have to notify probation director or whatever, or the parole officer has to notify the division within 48 hours, and then upon receipt of a change of address by a sex offender, but in no event more than 2 business days after such receipt, the division shall notify the local law enforcement agency having jurisdiction of the new place of residence and the local law enforcement agency where the sex offender last resided of the new place of residence. So, if the sex offender notifies the division, they have to, within 2 business days, notify the local law enforcement agencies, both of them, the old one and the new one. And if someone's on parole or probation, they have to notify their like parole or probation officer within 48 hours of the change, and then the division would notify the law enforcement agencies. Okay, K is registration from another state. A sex offender who has been convicted of an offense which requires registration shall notify the division of the new address no later than 10 calendar days after such offender establishes residence in this state. So again, this is a sex offender who has been convicted of an offense which requires registration in New York shall notify the division of the new address no later than 10 days after such sex offender establishes residence in this state. So not more than 10 days, not more than 10 calendar days. When a sexual predator moves to New York State, the division shall advise the board that the sex offender has established residence in this state. The board shall determine whether the sex offender is required to register with the division. The board's recommendation shall be submitted by the board to the county court or Supreme Court and to the district attorney in the county of residence of the sex offender and to the sex offender. The court shall determine whether such person shall be designated as a sexual predator, a sexually violent offender, or a predicate sex offender. L. The Board of Examiners of Sex Offenders shall consist of 5 members. The governor appoints the members of the Board of Examiners of Sex Offenders. So the governor is actually who does it, and it's 5 members. The board shall within 60 calendar days prior to the discharge, parole, release post supervision, or release of a sex offender, make a recommendation which shall be confidential and shall not be available for public inspection to the sentencing court as to whether such sex offender warrants the designation of sexual predator, sexually violent offender, or predicate sex offender. Okay, so M. Upon application of the sex offender or the district attorney, the court shall seal any portion of the board's file pertaining to the sex offender that contains material that is confidential under any state or federal law, provided, however, that in any subsequent proceedings in which sex offender who is the subject of the sealed record is a party and which requires the board to provide a recommendation to the court pursuant to this article, such sealed record shall be made available to the sex offender, the district attorney, the court, and the Attorney General, where the Attorney General is a party or represents a party in the proceeding. So what that's referring to is when they basically want to put the person away for like life because they're doing a proceeding under the mental hygiene law, and I believe that in that case the Attorney General would be a party. N. A determination that an offender is a sexual predator, a sexually violent offender, or predicate sex offender shall be made prior to discharge, parole, release to post-release supervision, or release of such offender by the sentencing court after receiving a recommendation from the board. N. Continued. The written notice for a judicial determination to the sex offender shall also advise the offender that he has a right to a hearing prior to the court's determination and that he or she has the right to be represented by counsel at the hearing. Okay, so petition for relief or modification. Both the sex offender and the district attorney can file a petition to modify the sex offender classification. P. The division shall operate a telephone number that members of the public can call free of charge and inquire whether a named individual is required to register pursuant to this article. Okay, so for the internet posting and the subdirectory, this is in Q, and it's talking about when there's someone who is a level 2 or level 3 sex offender. The subdirectory of those people shall be made available at all times on the internet via the division's homepage. Any person who uses information disclosed pursuant to this section in violation of law shall, in addition to any other penalty or fine imposed, be subject to a fine of not less than $500 and not more than $1,000. So basically, it's the same fine as a DWI. Unauthorized removal or duplication of the subdirectory from the offices of local, village, or city police departments shall be punishable by a fine not to exceed $1,000. So the first one that they're talking about, the fine, it's about information disclosed in violation of law pursuant to this section, and that was the 500 to 1,000. The unauthorized removal or duplication of the subdirectory shall be punishable by a fine not to exceed $1,000. No official, employee, or agency, whether public or private, shall be subject to any civil or criminal liability for any discretionary decision to release relevant and necessary information unless it is shown that such individual, employee, or agency acted with gross negligence or in bad faith. And this one's kind of a, joke to me. It's kind of ridiculous, but they picked the Valentine's Day month for the annual report. So this is S, the division shall, on or before February 1st in each year, file a report with the governor and the legislature. T, penalty. Any sex offender required to register or verify pursuant to this article who fails to do so within the time periods shall be guilty of a Class E felony upon conviction for the first offense, and upon conviction for a second or subsequent offense shall be guilty of a Class D felony. 168-U, unauthorized release of information. The unauthorized release of any information required by this article shall be a Class B misdemeanor. V, no person required to maintain registration under this article shall be employed, operate, or dispense goods for sale at a retail on a motor vehicle engaged in retail sales of frozen desserts. Okay, so eligible. Now this is the Article 23, 700. Certificate of relief. Eligible offender means a person convicted of a crime or offense, but not convicted more than once for a felony. Felony means conviction of a felony in New York, or offense in another jurisdiction for which a sentence of 1 year or more, or a death sentence was authorized. Revocable sentence means suspended sentence. 1. Suspended sentence. 2. Other sentence upon which execution was suspended. The penal law prior to 9/167. Or 3. Probation or conditional discharge imposed. Penal law in effect after 9/167. Convictions. 2 or more felonies charged in the same indictment are deemed one conviction. 2 or more conviction of felonies in different indictments or informations filed in the same court prior to entry of judgment under any of them shall be deemed one conviction. A plea or verdict of guilty upon which a sentence or the execution of sentence has been suspended, or a sentence of probation, conditional discharge, or unconditional discharge shall be deemed a conviction. 701. A certificate of relief from civil disabilities relieves an eligible offender of any forfeiture or disability, or removes barred employment automatically imposed by law to the conviction of a crime. It does not apply to the right of a person to retain or be eligible for public office. Generally, a conviction of a crime or of an offense specified in a certificate of relief from civil disabilities shall not cause automatic forfeiture of any license, permit, employment, or franchise, including the right to register and vote. Conviction specified in certificate of relief shall not be deemed to be a conviction barring employment or the right to a license, permit, or other authority or privilege covered by the certificate, provided, however, that a conviction for a second or subsequent violation of any subdivision of Section 1192 VTL committed within the prior 10 years shall impose a disability to apply for or receive an operator's license during the period provided by such a law. A certificate does not prevent any judicial, administrative, or licensing body or other board from relying on conviction as a basis for exercising discretionary power to suspend, revoke, refuse to issue, or refuse to renew any license, permit, or other authority or privilege. Certificate of relief from disabilities issued by courts. 1, it may be issued to an eligible defender if the court imposed a revocable sentence or imposed a sentence other than one executed by commitment to the New York State Department of Corrections and Community Supervision. Certificate may be issued at the time sentence is pronounced, may grant relief from forfeiture as well as disabilities, or at any time thereafter, may only apply to disabilities. For the court to issue it, it must be satisfied that 1, person is an eligible offender 2, relief consistent with rehabilitation of offender. And 3, relief is consistent with public interest. If the certificate is not issued at sentencing, shall only be issued thereafter upon verified application to the court, and the court may request the probation service of a county to do an investigation, or the state director of probation and correctional alternatives. If the court imposed a revocable sentence and the certificate is issued prior to the expiration, it's temporary until the court's authority to revoke sentence is expired. So basically, like if you get a sentence of probation and you get at the same time you get the certificate of relief, but then you violate probation, the certificate can be revoked. When temporary, such certificate may be revoked for a violation of sentence and shall be revoked if the court revokes the sentence and commits the person in institution under jurisdiction of the New York State Department of Corrections and Community Supervision. If it's not revoked, it becomes permanent. Court may enlarge the relief previously granted. Written reports submitted are confidential. However, the court may make it, the court shall make it available to 1, applicant's attorney or the applicant if they have no attorney. The court may accept from disclosure certain parts. They may have a conference in open court or in chambers. They may conduct a summary proceeding and may take testimony under oath. The State Department of Corrections and Community Supervision shall have the power to do this. The vote of board granting or revoking a certificate shall be unanimous. The State Department of Correction and Community Supervision shall issue a certificate on the recommendation by a federal court unless requirements to issue a certificate are not satisfied. A certificate of good conduct, the same thing basically. It's not a conviction, is not deemed to apply to any license, permit, or other authority or privilege covered by certificate. However, a conviction of an A1 felony or a violent felony imposes disability to apply or receive a license per Penal Law Article 400, which is firearms. It can be issued, but this is the good conduct, could be issued by the Department of Corrections and Community Supervision. The minimum periods you have to be good for before you could get it is for a misdemeanor it's 1 year, C, D, or E felony it's 3 years, and the A or B felony is 5 years. The period of good conduct is measured from 1, the date of payment of any fine that was imposed, 2, date of sentence, 3, date of unrevoked release from custody by parole, 4, date of commutation of sentence, COMMUTATION, not sure what that is, or date of termination of sentence. The board may at any time issue a new certificate enlarging previous relief granted. A person who knowingly uses a revoked certificate shall be guilty of a misdemeanor. A certificate shall not be deemed to be a pardon and does not alter a person's right to apply to the governor for a pardon. It's a judicial function, and if done in conformity with the law, it's not reviewable.